Mark. Appreciate the presentation, the information. So when I was doing introductions, I failed to recognize a couple people. One, in Idaho, we have a unique recognition from our DC offices of the value of the dairy industry and the value of agriculture, and extended an invite to all 4 delegation member offices. And this front table up here, these gentlemen, raise your hand, guys, if you're from our congressional staffers. Appreciate the fact that you extend an invite to our Senate and House offices, and they recognize the value of the dairy industry and the possibility that there might be some policy discussions around methane digesters in the interest. And our DC staffers and their bosses have instilled in them the understanding that dairy is important, and so I appreciate the 4 of them being here. We also have extended an invite to some of our local politicians, and Charlie Howell, he's trying to hide in the back. He doesn't like attention. But Charlie Howell's the chairman of the Jerome County Commission. Appreciate him coming as well. He's one of those counties where there's a lot of interest in this topic, and appreciate him coming here to learn today as well. So touching a little bit, Ari, on what you had talked about with, how do we figure out how to be able to get manure further away from the dairies, and how do we solve that nutrient loading problem? One of the things that we wanted to highlight today is a farmer learning network that we're working with in concert with Farm Journal. This is something that Marissa Watson with Dairy West, and Ethan White looks like he snuck out of the room. Oh no, he's in the back getting more coffee. And then also Michelle Rossman with the Innovation Center are going to spearhead. But really it's looking at trying to bring farmers together, because we recognize the first thing you do when you're trying to discover, okay, I want to make an investment, I want to add something to my manure system or some other change in your dairy, is you ask other dairymen, how did you have that technology, how did it work for you? So we're trying to formalize that a little bit into what they're calling a farmer learning community. And so if you have an interest in being part of that, the vision is to bring dairymen together and to have periodic conversations in person and looking at different things that are working. It could be a manure system, it could be a digester, it could be something in a cropping system that is working for you, but trying to bring those ideas together and formalize that a little bit. The importance of Farm Journal and Innovation Center being involved is they're going to bring resources to the table. So if we did want to bring in different speakers or different ideas, they're going to help us make those connections, but also get that expertise in the room for us. And really, as we're looking at net zero, that's something that I know a lot of dairymen cringe when they hear net zero. But as we're looking at trying to figure out how do we get to net zero as an industry, this is a group that will also give us a really good feedback loop to be able to push information out, but also receive feedback from dairymen as to how you think different concepts are hitting you and what that looks like to you from a producer level. So if you have an interest in being part of that, please, Marissa or Ethan or Michelle, please talk to them when we get to the social hour and seek them out and let them know that you might be interested in being part of that learning community. So next we've got David Claiborne up here to talk about due diligence. David is legal counsel for the Idaho Dairymen's Association. He's a partner with Sawtooth Law. He's worked on behalf of IDA for a number of years. I'm not sure how many at this point, David, but he's somebody that we also knew had done some due diligence. Their firm's done some due diligence on different digester projects over the last couple of years. And so I asked David to come and just speak to some of those due diligence questions that dairymen should ask as they're looking at a digester project or if they're being approached. So David, if you wouldn't mind coming on up here and providing your brilliant expertise.
All right, thank you, Rick. As Rick mentioned, I'm David Claiborne with Sawtooth Law. I have Evan Roth, one of my partners here, and an associate, Katie Vandenberg Van Vliet. And the 3 of us kind of kick around these issues and work on, yep, that's the right slide.
Got it?
Yep. How is this? Okay, I have to learn how to use this. So we kind of work on these issues mostly for dairymen. We have some digester company clients as well. And going to try to this afternoon just go over some of the due diligence things you should think about as a dairy producer as you're starting to talk to digester developers. We won't have time to get into detailed nuances of every particular transaction, but I think we'll be able to give you a good overview of things you should start thinking about and things you should be asking a developer as you move forward on your own project. So every county's unique and every dairy's unique, and so the questions would vary based upon your situation, but we should be able to go through it fairly well. From a process standpoint, I mean, I think everyone should know it's a negotiation from start to finish. You're going to be dealing with, big businesses, energy companies, but you're big businesses too. And so you need to be strong and negotiate. Involve early on your trusted advisors, whether that be your legal counsel, accountants, your lender, those sorts of people. They need to be involved and know you're getting into these discussions, and what you see, the vision is that you would have for your dairy. Early on, as you get approached, that you'll be probably approached with a non-disclosure agreement. That's pretty common. You want to make sure that that's mutual, that that's going both ways, so that any information you're giving the developer is kept confidential, as well as information that they might be giving you. And it's important that in that non-disclosure agreement, you're getting that ability to get information from the developer. So it needs to be bilateral. At the same time, you start those discussions, you start working towards that letter of intent. That's more like that's a term sheet. It's not a binding agreement. You want to make sure it's fashioned in that way, but it'll outline usually a due diligence period where the developer will want to come in and start poking around on your dairy and starting to learn more information about it to see if they can make a viable project. But like I said, at the same time, you want that to be bilateral, so you would want to be making sure that the letter of intent gives you due diligence rights as well to start investigating the developer company to find out, are they legitimate? Do they have financial backing? Is this somebody I would want to be in business with and be doing a project on my property? We're going to go into a few areas of just kind of broad areas I think you should think about when you're negotiating terms. It's going to lead toward, if you get through that letter of intent phase, and I'm sorry I kind of blew by it, if you get through that letter of intent phase, you're going to get into a contracting phase where you're going to start negotiating terms of a feedstock supply agreement. That's the agreement that basically by which you send manure to the digester, it's digested and comes back to you. And then there's going to be leases for them to site infrastructure on your property, or potentially it may start with a lease option and then fold to a lease. It just depends on the nature of the transaction. And there's going to be negotiations that are going to bring your lender in around SNDAs, or subordination and non-disturbance agreements, because the digester developer is going to be wanting a leasehold interest, as it mentions there, and usually that's going to conflict with terms of your mortgages and your lender's rights to approve the granting of a leasehold interest. And so you're just going to have to, get with your lender on that to understand what the terms might be for SNDAs to be entered into. It's going to vary by lender, but what we're seeing is that we're able to work those out. You just need to get them scoped down to the footprint the digester will be occupying. Be careful not to be granting some sort of carte blanche interest over the entire facility. The lender's not going to like that. If you get through that contracting phase, then you're going to get into the permitting phase, where the digester company is going to start to try to secure all the permits they need to construct and to operate. We're going to talk a little more in depth about that later, because there's elements of that you should think about. During that permitting phase is usually where you're going to nail down a specific site location and digester design. After that's construction, and then hopefully you're on to operations. So as you're contracting, you need to make sure that you're thinking of your internal ownership, so the right entities are party to the contract. Some of us, probably because of your lawyers or whatever, you make these complicated ownership structures. And so one entity might own the land, one entity might own the cows, one entity might run the dairy. So you've got to make sure you know who those entities are and that they're the proper parties to the contracts. We're going to talk a little bit later probably also about some assignability interests and estate planning considerations, but these are long-term contracts. So one thing to think about is the LLC structure with a manager-managed entity, and that provides a little more flexibility as you think about, am I entering into a 20-year feedstock supply agreement? Am I still going to be running this dairy in 20 years, or am I going to be passing ownership on to somebody else? And if I want to do that, to what extent am I going to have to involve this digester company now to make that transition? Because they are like you, they're going to be wanting to get into business with you and not with somebody else. So we got to think about those things. And it's all negotiation for your terms, and we'll talk a little bit more about assignability in a bit. Likewise, as you think about your internal ownership, think about the digester's ownership as well. So, like I've mentioned before, I want to really stress that due diligence needs to be on both sides. You need to be doing due diligence too about this developer, who's approaching you, and some questions to ask are up here on the slide is, what projects does the developer already have? And are they under contract with other dairymen? Are any of them in your area? Can they arrange for you to talk with people that they've done projects with so you can get a feel for how they are to work with? Does the digester developer have in place long-term contracts to sell their energy? I mean, that's important. We want to know they have a market, and with who. And like I say there at the end, if they're a successful digester developer, they're going to be willing to answer these questions and talk about them. They're going to have pride in the projects they've done, and I would hope they wouldn't be hiding and saying, oh, it's all confidential. They should be able to demonstrate to you that they've done projects, they're viable, they have the wherewithal to do a project. Similarly to the ownership issues, we have the financing considerations. So you got to think about your internal financing. Who do you have your lending with, and what consents might they need as you proceed? You're going to need to talk to your lenders so they know what you're planning to do and what lien interests they might have. So undoubtedly you're going to have a lender with a mortgage, or more likely a mortgage, and it's going to have elements of that mortgage that will impact the need for lender consent for the contracts you would need to enter into with the feedstock or with the digester developer. And similarly, they're probably going to have a security agreement and UCC lien on your cows. Now, manure is an interesting question, and I have not yet seen a UCC lien asserting a security interest in manure, but it's possible, and so it's something you'd want to think about. And we're going to talk a little bit later about that issue. It's somewhat of an emerging issue. But definitely you got to look to see what liens are out there on my land, my cows, and my manure, and we have to make sure that those lenders are involved so that they're providing any consents they need for the digester development. And then again, like I say, going back the other way, you want to look into the digester developer's financing. So does the developer have financing and funding in place? With who? In what amounts? Are there contingencies and conditions to it that could hold the project up, or where the financing could fall through? Questions to ask would be, who will be receiving carbon credits and the tax credits? It's not going to be you, but if they're able to answer those questions, that would demonstrate that they have backing and a market. And then negotiate toward obtaining access to financials and corporate information of the developer to just see the hard evidence or the proof that they have been able to develop projects and that they are operating them. So next would be a primary consideration is, what are you going to get out of it? What's your compensation to the dairyman? So there's various points at which compensation in a typical transaction would be coming your way. The first is at signing. So it could be at that letter of intent, or it could be more likely at the signing of a feedstock supply agreement that there would be some sort of signing bonus that would come your way. They're gonna vary in amount, but obviously that's something you wanna negotiate for. And then there could be progress payments as the project begins to move forward through those processes I discussed. So you might look, am I going to get further progress payments at lease signing or the signing of a lease option, or when permitting is secured, or when construction begins, and when commercial operations start. Those are various points where you would look to see some sort of progress payment being made toward you. Then once commercial operation starts, you look, and Mark was talking about this, there's different ways that you can be paid as the energy production begins. And so I think what Mark was talking about on his slide was a per cow. And so he was assuming you were getting paid a fixed amount per milking cow. I assume milking cow. It could be all cows, or heifers could be included. And it could vary by whether they're in an open lot or a feed stall or a free stall. So those are some structures. Another structure is a price by the energy unit. We will pay you a fixed price or a variable price determined on market conditions of the energy unit, which in most cases is going to be million BTUs. Or it could be a profit share approach, which would say you get a percentage of net income. That's usually expressed through a formula, an accounting formula called EBITDA, EBITDA, which means earnings before interest, taxes, and depreciation and amortization. And I think it's important, if it is going to be a profit share arrangement, you need to really dig into how that EBITDA formula is going to work, see calculations from the developer as to how it would work in practice. The issues become the extent to which non-cash versus cash items and income, such as credits, would be factored into that formula. So those are the three kind of methods, and sometimes it's a blend of we'll pay this or this, whichever's less or whichever's more, so there's different nuances to it. The next thing to think about is the effect of having a digester on your facility will have on your animal operations and your ability to control those operations. Undoubtedly, you're going to lose some control. So the digesters, they want to maximize that CI score, and their concerns surround total solids and volatile solids and other aspects that would affect the energy qualities. So a few things that you want to think about on the animal side is, can I change the rations that I give my animals? Because that can affect the manure coming out the other end. So can I do that? Is that just my call now, or do I have to go get permission from the manager of the digester before I can do that? Same thing for my animal bedding and my housing, where I keep them and how I keep them. Over your herd size, okay? So can I add cows? Can I subtract cows? And can I do that without consulting with the digester? And big one is your water use. And how much water is being used coming out of the parlors, the stalls, foot baths, the extent to which you can use copper sulfate. We talk about health management down here, the use of antibiotics and other medications that might pass through the cow and end up in the manure stream. So the digester company is probably going to be interested in all those things, because it all affects the quality of the constituent quality of that manure, and inevitably the CI score. So you want to be looking in that feedstock supply agreement the extent to which the developer is now going to have input on what traditionally you probably just made the call on as the dairy producer, as the dairyman. The same happens on the waste management side. So the digester developer is going to be part of that process. And again, it's an issue of control for you and how much involvement the developer will have in that when operations start. But you're going to want to talk about, how you're using flush water, what bypasses will be available, in the event that work's being done on the digester, how can we go, bypass it, go around it? You might use honeybacks and solid separation now. Are you going to continue to be able to use that if the digester's on site, and whose decision will it be? Any other pre-digester handling and treatment that you use would have to be discussed with the developer, negotiate how you would manage that going forward, and how would changes be made. How long will the manure be in digestion? That's important for managing the lagoons. Mark talked about how that varies between the 3 different styles of digester design, and then what's the nutrient value and composition of the digestate? By that we mean what's coming out the back end back to you. So they're taking your manure for a period of time, they're giving it back. When it comes back to me, it's going to be different than when I gave it to them. What's it going to look like? And how is it going to end up coming to me? Is there going to be post-digestion separation or treatment? And what I put in this element here of temperature control and digestion and outflow because our climate is variable. And so one thing to be thinking about when you're talking to a developer is how are they going to be managing temperature in the lagoon while the digestion activity is happening, and who's going to pay for that? Okay, because they may have to use energy resources to maintain a certain temperature during the winter months, and there's going to be a cost for that. And who pays for changes and upgrades, and who pays for transportation of manure to the extent it's necessary. Most of this is on farm. The effect that the digestion will have on the frequency of lagoon cleaning and how often you'll be able to do it. And then the big one, after you figure out through all this stuff, now what changes have to be made to my NMP with the Department of Agriculture? How does it affect my field applications and my third-party exports if I'm doing that? Inevitably it's going to require changes to your NMP because the manure is just going to have different qualities, and so how it's being used and applied on the land, there's going to be some changes there. So I talked earlier about the permitting considerations, and this slide kind of discusses that. Each county varies, so it varies from a CUP process to a CAFO amendment to a variance to no process at all in some counties. And you'll have to figure that out with your developer for how your county's going to handle that. And the big thing to think about is my current, pull out your current permit, understand it. Do not agree in your feedstock agreement to having more milking cows than your permit allows. So more than likely, if you have a county process, it's going to trigger some sort of site review or an inspection before they issue the new permit. And sometimes your cow numbers may have creeped up above your permit allowance. Sometimes you may have built structures or added to your facility without getting a permit. But now you're going to have county officials walking around and checking for site review. And so you want to make sure you know that before it becomes an issue. It does create the potential when you're filing for permits for the digester to now, if you are out of compliance or have some non-conforming use, to get that permitted and approved, because it just presents a favorable opportunity where you're talking about an eco-friendly project to potentially get some things brought into compliance. Additionally, it creates an opportunity time for a CAFO expansion. So we kind of internally have just been calling it a stacked approach, but by stacking, we mean you got 2 permits going on here, the digester permit, which will be a CUP, you've got your AFO or CAFO permit. You want to try to keep those separate and not have them on the same permit. So if something happens with that digester development, it doesn't affect your ability to continue the dairy operations or affect that permit. And then what you want to look for on the CUP, because this varies by county too, is who holds that permit? Is it the landowner or the digester operator? And if it's the digester operator and that the company leaves for whatever reason, does it transfer to the landowner automatically, or do I have to go back through a permitting process? So in my transactions, ideally, I'm trying to look to have that permit, have a condition in that permit that if it's issued to the digester, that if they leave the operation, it automatically will transfer to the owner, the underlying landowner of the land, so then you can operate it without having to go back through permitting processes, public hearings. Down here, you're probably gonna have to have neighborhood meetings, county meetings with the commissioners or planning and zoning, other public hearings. So if we can avoid those, we like that. Will there be a need for an ISDA inspection? Again, something that varies by county, but probably there would be. And, we're pretty secretive and protective of our nutrient management plans. In Idaho code, they're protected from public disclosure. But their protection from public disclosure probably only, arguably applies to what you've turned in with ISDA. So be careful about ever giving those documents to the county as part of the permitting process, because I would say you probably then lose that protection. If you don't care, I guess you don't care, but it's something to think about. And if you do have a need for an ISDA inspection, work towards the county being, rather than being provided with your NMP documents, a in compliance letter from ISDA. There'll be a slew of other permitting things that go on with the developer, with the digester. They will handle most of that, not you, particularly with DEQ and other agencies. Okay, so operational concerns. Maybe I did. Anyhow, be involved and ask early regarding the digester design, location, and operation, how it's going to work. Where will the interconnection point be to the energy transmission pipeline? And, might be on or near your dairy, might be miles away, but where is it, and how is the gas going to get there? And then what utilities are needed to operate the facility? Who's going to supply those? Is it going to be on its own meters or on your meter? Who's going to pay for it? What happens if there is a shortfall in manure delivery? So your feedstock agreement is going to require, when operations begin, that you're supplying some level of material, manure, to run the digester, and you're going to want to look in that contract and be asking questions about what happens if there's a shortfall. Are there penalties? In what amount? Are they immediate? Do I get days, or is it just on day one, or does it happen after day 5? Various deal points to negotiate there. The potential for releases always exists, always a concern. So the contract's usually going to talk about liability for those releases, and you're going to want to look to see how that's allocated. I would say typically that until it reaches input at the digester, any liability for release is going to be with the dairyman, and you're going to have to indemnify the digester from that and provide insurance for that risk. Then once it gets into the digestion facility, those responsibilities flip and go to the digester, and at that point they're responsible for maintaining the manure, preventing its release, indemnifying you from a release, and insuring on the risk. And once it comes out the back end of the digester, it's back on you. But be aware of those and look for those provisions. The other is force majeure events. Now, force majeure is just our legal term for a situation where the parties to the contract are unable to perform because of circumstances beyond their control. And there's undoubtedly going to be a force majeure provision, and it's important you look at that to see what events that are going to be deemed outside of your control, where if you fail to deliver, you can't be penalized under the contract or declared in breach. And so the things we negotiate for is severe or unusual weather, freezes, and prolonged low temperatures. So we have a cold climate, and sometimes it gets so cold that manure is not moving the way it should, and when that happens, it can affect the ability to get the manure to the digester And I think that ought to be a force majeure event where you can't be penalized because weather's preventing your manure from flowing. Another would be an upset condition, which is defined by Idaho's Dairy Environmental Control Act and governed by ISDA. The other would be herd infection or disease outbreak, so anything that would affect the ability of the cattle or the health of the cattle. And then one here, production curtailment order. So sometimes, because of market conditions that you don't have control over, your processor might give you an order to cut back milk production. That's a circumstance really beyond your control. You're contractually bound, and that's going to affect, in some circumstances, the ability to keep producing the manure demand that the digester might want. So I feel like that's an important term to look for or to try to get in your feedstock supply agreement. Term and termination. So there's going to be a term for how long this arrangement will last from the date you start commercial operation. 10, 15, 20, 25 years, who knows. But you're going to want to understand that and know what it is, and know, think about your operation, your plans, your future, and is this a contract you want you and your family to be bound to for that period of time, including within that the renewal and extension terms. And they're going to come, if you have a 10-year deal, it'd probably be 10 years with maybe 5-year extensions. You just want to understand that, and then for those extensions to occur, at whose option do they occur? So does it require both sides, both the dairyman and the developer, to agree to the extension, or is it one-sided where just the developer can say, we want to continue for 5 years and then you're bound? And are you okay with that? So that's something to think about. What happens to all those facilities on termination? So they're going to put facilities on your property when this deal's run its term. Do they stay or do they go? And whose responsibility is it to remove them if they go? If they stay, do I now operate them and I get to run the digester? And make sure that do all the permits transfer to me? And the assignability of interests, like I say, it goes both ways. So there's probably going to be provisions asserted by the developer that would prevent your ability to assign ownership of your dairy to somebody else. And so you've got to look at that and see, are they asking for that provision, and are we okay with that? Can we negotiate for terms that would allow me to assign or transfer my ownership to family members without permission of the digester? So it's just you're gonna have to think about the future of your dairy and whether you're gonna be directly involved in that for the term of the contract. And do I want provisions in there that would let me assign or transfer ownership to the next generation of my family while this contract's still in place? But then likewise, I think it's important to think about, well, what about the digester developer's ability to assign their interest? So there's developers out there that are just trying to get dairymen under contract, and then they want to flip that contract and sell it to somebody else. And so you think you're entering into a deal with somebody, and then once you sign, they turn around and send it to somebody else. And so you're not in a deal with who you thought you were with. So personally, I try to look for assignment provisions that would limit the ability of the developer to assign without mine, the dairy producer's permission and consent. And so think about that and look at those assignment provisions. I think Mark touched on this, but exit opportunities are important things to look for too. So you could have a buyout option in that feedstock agreement that would let you declare the contract over, in which case you would have to pay some money to the developer to compensate for their investment. And then likewise, it could go both ways. So that's an exit opportunity after the deal's operating. There are other terms you can negotiate for in the different phases that I talked about earlier, such as, before we go to permitting, do we want an opportunity for each side to end the deal and say, deal's off, here's my signing payment, you can have it back, let's cancel this? And do we want more of those options at other stages, like before construction? So just think about that, and don't be afraid to negotiate for those types of terms. There'll be provisions in the feedstock agreement that are going to talk about taxes. So effect on, once they put a facility on your property, it's going to affect the valuation of your property. It's going to make it go up. The land's going to have more assessed value. So who pays that incremental increase? Does the digester developer pay it, or are you paying it? And is there a provision in the contract that talks about it? You want to look for that. That's a negotiable point. The allocation of the available tax credits for siting the infrastructure. So sometimes there might be tax credits available just by the fact that you built this infrastructure on your property. And so you'd want to think about who gets to claim that tax credit, or is it shared? Is it allocated? These top two here, I think, are negotiable deal points. The bottom two are less so. But is there a tax on the production and sale of manure? If so, that's probably going to fall on the dairyman. And taxes on the production and sale of energy are usually going to be paid by the digester. We're going to talk a little bit more in just a moment about the sale of manure. And here we are, sale of manure. So, emerging issues, things that we're thinking about and talking about that just kind of aren't resolved yet. One is the community digester, where multiple dairies might be supplying manure to one facility. So the concern I have there, and the item to think about on that, is the risk and liability for that. When you start to lose control over the manure that's going into the digester, where you may have responsibilities for what goes in there, and your payment's tied to that, you lose that control when you do a community digester. So if somebody does something, if your neighbor that is also adding manure does something where hazardous materials or high levels of copper sulfate or something end up in the manure, and they end up in that community digester, well, there's going to be contract penalties for that. Now, how do you know which dairy it came from? How do you allocate that liability? That's something we're thinking about and trying to figure out. The co-digestion aspect that was brought up, where you introduce other materials, other meaning something other than manure. It could be the fats and oils and greases that Mark was talking about. It could be whey or other non-manure product, and what impact that has on permitting requirements, such as the solid waste permit. The sales tax issue, I don't know yet, and I don't think anyone here from state government, but we don't know yet. This transaction where you take manure as a dairyman, you give it to a digester company for compensation, and then it's returned to you. What type of transaction is that? Is it a taxable sale? So I'm not aware of the state of Idaho collecting a tax on that yet, but I wouldn't put it past them to say it is. So you got to think about, do we want to protect against that in the contract and say, if if this is a sale and there's a tax, who pays that tax? And similarly, the collateral interest in manure. So I haven't seen many UCC liens that claim a collateral or security interest in manure, but they do in your cows, and there's this concept in the law about the security interest attaching to proceeds of the collateral. So is manure a proceed of a cow? And if so, is there a security interest in it? Why does that matter? Because the feedstock supply agreement is probably going to have a provision that says you're granting the digester company the first lien position in your manure. And so that sets up a conflict with your lender if they're claiming a UCC lien on the proceeds of a cow claiming its manure. So those are kind of things we're still trying to figure out, and they haven't been resolved yet. Let's see I think that might be it. That was all I had. Appreciate your time, and I'll take any questions. We good on time? Yeah. Questions? Did I overload you with information? Nothing. All right. Oh,
So we have an understanding, you lease the property to develop. Is that the correct way of looking at it?
say it again.
The way I'm listening to this is that when the developer comes on your property, wants to put the equipment and all this stuff on your property, the developer is leasing the property from you, okay? So the question really comes to what rights do the developer have over that lease? Like if I want to do financing for my real estate, does the developer, because he has a lease, have to sign off on loans and so on and so forth?
Yeah, it's a good question. And the answer is probably yes. So I kind of breezed over that earlier on with the SNDA discussion, but yes. So once you get through that phase where you're contracting, you enter into leases, then the lease, there's going to be subordination and non-disturbance agreements with your operational and land lender, but there will be provisions then that will lock you in terms of if you're going to change your financing, that the digester developer would be involved in that again with those SNDAs. So really, once you enter into these agreements, there's any future financing deal is going to involve you, your lender, and the digester company.
And then, do I have to provide financials to the developer every year annually when they demand such a thing?
I haven't seen that.
David, if I could jump in there for half a second.
Yep, go ahead, Tim.
On that future financing provisions, depending on the lender, depending on where you guys stand collateral-wise and what kind of your loans look like, some of those SNDAs do not require the digester companies to come back in and approve of additional financing. That would be the ideal result, is that you don't have any interaction with them after that. As it relates to the financials, that's a mixed bag right now. Some guys are requiring it, some aren't. It's kind of all over the place.
Yeah, go ahead.
Another question. So let's suppose you're in this deal with the developer for about 3 years, and you have conflicts and you cannot come to a remedy in this conflict. And then you part ways, then what happens to the equipment that's on the leased property?
That's a point you've got to negotiate. So that's going to be in the feedstock supply agreement, and it can vary between the facilities stay or the facilities go. That's just a deal point that's got to be negotiated.
So in other words, let's say we can't find a remedy, I could basically put in your contract, say, okay, disappear, take your stuff, but at your own cost. I could put that in the contract, would that be something acceptable?
I'm having a little trouble hearing you, but
A little closer then.
there you go.
Okay, let's suppose in the course of, you can't find a remedy, you put in your contract that we separate. Okay, to the developer, you take your stuff off my property. And is that something that I would have to put in there?
You'd have to put that in there, and you could negotiate toward that. I would suggest the developer would probably want compensation in that event because they've made an investment in the project and they're losing out on future revenue. So it's probably going to have to be negotiated how that's determined, what's fair between the parties, and it's something to think about up front and negotiate while the two of you are getting along, not doing on the back end when you're in the middle of a fight.
One more comment on that too. Generally, you're seeing land lease agreements, and then you're also seeing a feedstock agreement. You want those documents to be cross-defaulted, so if there's a default on the one side where they're not accepting your manure, they're not processing it through the digester, it also terminates the lease agreement, so that you don't get stuck with a feedstock agreement that's defaulted, and then they still have the lease or the option to be on your property. So you want those cross default to mean that you can kick them both off at the same time. And then you start talking about revisionary interest. So can something come back to me? What are the terms that it comes back to me? So that's kind of that buyout language that David's talking about.
All right. Very good. You got it, Rick?